Yes, Mr. Salve.
Yes. But I'm only to, as my note said, I'm only supplementing some of the submissions which have been made already. And I've just picked up the issue. One is, my lord, construction of the proviso to sub-article 3 of 370. The attorney has addressed your lordship at length. Only a few points to add to what he has said. The width of power under Article 370, because that has been the subject matter of some discussion. The nature of the power exercised by President under various sub-articles of Article 370, there was a suggestion made that this might be executive in nature. The absence of a challenge on administrative law principle of abuse of power. It's necessary to get a few concepts in their right perspective. The exclusion of judicial review beyond the question of competence, questions that are political in nature. And the use of power under 356 to make changes that may be irreversible. And finally, the violation of basic structure. Very short submission in each of these headings. The first point, my lord, relates to the construction of the proviso. Your lordship have heard detailed submissions by the solicitor and by the attorney. And my lord, I just want to put it in a frame. So normally, these are the three aspects which one would look at: the textual, the contextual, and the historical. We have, my lord, and the solicitor read it out to your lordship. The author of the provision and the list of dates given by the solicitor sets out in detail the confabulations, including differences of opinion on whether there should at all be a special treatment of Kashmir. Then, my lord, Gopal Swami Iyengar's draft, its brief discussion, and its adoption by the Constituent Assembly. And one thing was clear: this was an element accommodating certain compromises, political compromises within the constitutional framework. Your lordship has read all of that. I'm not going to repeat reading any of that. But that has been sufficiently put across. And it now stands as it does. And its words have to be given their plain meaning. So, my lord, the first thing your lordship would do in my respectful submission is the textual bit. Now, in the textual bit, what is of great significance in this point has been put. If the idea was that the president could act only to give effect to a recommendation of the Constituent Assembly, then that would have been made the precondition for exercise of power. Perhaps the article would have said, if a recommendation is received from the Constituent Assembly, then the president may. And your lord, in fact, in the course of the hearing, my lord, the Chief Justice gave the example of certain other articles where it says, if a reference is made or if something is done, then. But that's not the frame in which this was drawn up. One of the articles, my lord, of that kind is 249. Courts are very well familiar with that. It starts by saying, if the Council of States has declared by resolution, then it shall be lawful to make laws. So that is a precondition for the exercise of power.
But Mr. Salve,
yes,
does the proviso to Article 370(3) does not bring about the same result?
Yes.
By the use of the expression shall be necessary.
Yes. So, my lord, shall be necessary here must then be subject to the principle that if there is a Constituent Assembly then it's first of all, the word is recommendation, not concurrence. And secondly, that becomes necessary because if there is a Constituent Assembly, then you cannot act in vacuo. That was, in my respectful submission, the textually, because we must first of all discern legislative intent out of language. And from the language, when the Constitution knows, or the drafting of the Constitution, the authors of the Constitution knew that there were certain models in which it says, if something is done, then you may exercise a power. Is the president to act, my lord, only to give effect to the desire of the Constituent Assembly, or is he to receive a recommendation from the Constituent Assembly? And obviously, the compromise was he must receive a recommendation from the Constituent Assembly, which obviously means if there is one, he must. Secondly, my lord, this very article, and we have all this is textual. This very article uses two separate expressions. B2 uses the word concurrence. I mean, it's a point which has been already made. And the proviso uses recommendation. Now, if, my lord, one had put concurrence here, the argument would still remain, but it would have been a much stronger place for the Constituent Assembly. So while, my lord, distribution of the fields of legislation in subarticle B of, in clause B of subarticle 1, was put as concurrence of the government of the state. At the same time, subarticle 3 used the word recommendation. It's not an amendment, it's not this. So, my lord, one must assume, and this was a article which had internal dissensions and differences, and it was very carefully crafted between the within the committee and within the assembly. There were differing points of view. So, my lord, we must give meaning to every word of this article. So the difference between concurrence and recommendation and its framing as a proviso. At two places, again, subarticle 2 says, if the concurrence. So, my lord, this is a very conscious departure from the concurrence, recommendation, consultation, recommendation, concurrence. One would perhaps say the difference is, if you fail to consult, it is not fatal. If you fail to obtain a recommendation, if a recommendation is necessary, it is of more serious consequence. Would it be fatal? I don't know. Concurrence, obviously, because concurrence, then your power gets hedged in. And this is all textual.
So, Mr. Salve, there is one countervailing consideration
Yes,
which
yes.
we possibly may have to bear in mind.
Yes.
That where a change in the distribution of legislative power was envisaged,
Yes.
the provisions spoke of concurrence,
Yes.
except in the area which was covered by the instrument of accession.
Yes, ma'am.
The exercise of the power under the proviso to clause 3 brings about a complete abrogation of status.
Correct, ma'am.
Abrogation of 370.
Yes.
In which case, all the limitations which are even introduced by the earlier provisions of clause of Article 370 are lifted.
Yes.
Including the concurrence on the distribution of legislative
Yes,
power,
yes.
consultation.
Yes.
Now, could it have been the intent that you require the concurrence for altering the distribution of legislative power or for altering any other provision of the Constitution. But for abrogating the article itself, nothing more than a mere recommendation is required.
Which, my lord, drops me, I'm deeply obliged, my lord, which brings me to the second, the contextual.
Power under the proviso is exercised,
Yes.
then there is no limitation at all.
Absolutely. And that, my lord, brings me to B, the contextual. And in fact, that was the direct intent. And your lordship will see it from another point of view. There's another point of view. Till the arrangement is in place, unlike other states, where the constitution sets out legislative powers in the seventh schedule in absolute terms. And you need a very elaborate mechanism to tinker with those seventh schedule. It has to be with 50% states voting, etc. Your lordship knows the difference. Here, there was a political agreement and the whole circumstances, including, as Mr. Anger spells out, the specter of the United Nations, which today is, of course, irrelevant, but at that time was very relevant. The problems in the state. So there was a agreement which is embodied in B, which has concurrence. But if this led to a situation which ultimately prevented the purpose of 370, the purpose of 370 was not to create a permanent divide in the constitution. Lots of material has been shown to your lordship on this. It was a phased integration. I'm going to deal, Dr. Dhawan has raised a very interesting point of asymmetric federalism, whether that became part of the basic structure. I'm going to deal it separately. But the historical material available to a court, and we have, unlike certain other courts, we have always looked at historical material, especially for articles like this. There was a safety valve in sub-article 3 that if the political compromise in sub-article 1 fails to achieve the purpose, at any time it might become necessary to pull the plug. And sub-article 3 is that plug. Now, if one looks at it that way, the whole thing falls in place. The framers of the Constitution kept with the President the power to do away with this special arrangement.
Yes.
And history bears testimony to the foresight and wisdom of those, despite the criticism at that time and the political debate which must, in a democracy, you must always have the noise of a democracy, Mr. Bhutto used to say. The noise of the democracy is the most essential element of a democracy. So this has been the subject of debate. But your lordship has seen the entire history of how phase by phase this has been narrowed down. The divide has been narrowed. More and more subjects were added. More and more alignment was brought about. Because the historical perspective of 370 is very important. The troubled relations. While there's always was a hope that the relations with the neighboring country would be on good terms, the history of Kashmir did give rise to apprehensions. And your lordship has seen all the material. So border state, with all its sensitivities, is what compelled finally the Constituent Assembly to agree to the special arrangement. But with their wisdom, they said, while you phase it in, you have the power to pull the plug. And this is what I call the contextual interpretation. So the plain language, pure text, and the context.
What is the context, Mr. Salve? How is it distinct from the historical background or the plain text?
The context is that this read by itself, forget the history, this read by itself shows that in subarticle 1, there is a divide in the legislative list base aligned to not the constitutional general 7th schedule, but to an instrument of accession. Broadly, the idea was aligned with the instrument of accession. That's how the powers will be shared. And a partial application of the Constitution of India, not in its entirety, but such other provisions. That's the D. That's the context. With a safety valve in 3. And my lord, the history of this provision also tells us it may be difficult to find a logic in each of these because these were a political compromise. Why was the Constituent Assembly put there? That was a compromise. A lot of things are done to assuage ruffled feathers. There were 2 approaches. One was the jackboot, saying doesn't matter, things will settle down, don't agree to anything special for Kashmir. The other was the other extreme, saying if the legitimacy of the accession is being questioned and there is a popular uprising, accommodate that. This was the compromise. So, my lord, one cannot search for too much logic. This was the compromise form. And we must therefore, my lord, the safest thing for a court, in my very respectful submission, as a matter of constitutional interpretation of such provisions, and such provisions are essentially political, and I don't mean political in its pejorative sense. I mean it political as in its constitutional sense. The court has always said you must give it the widest possible meaning. In fact, my lord, I'll give your lordship that passage. Justice Pandian, I think Justice Pandian, in his majority opinion, where he upheld the abolition of the privy purse, where your lordships upheld the abolition of the privy purse, he says that our constitution was meant to be flexible in these areas.